Welcome, everyone. Uh, Today's Supreme Court judgment primarily revolves around a question that to whether criminal proceedings can be quashed under 482. Now, before I go into the story and tell you about the details, let me just tell you what all other statutory ingredients are there in this particular judgment, तो आपको भी समझने में आसानी होगी. There was a complaint at the police station filed under section 354 and 506 IPC. And अगर आपको पता है 354 is for outraging modesty, and then 506 is for criminal intimidation. So the complainant who filed the complaint uh, mainly on these two sections. Now, let me tell you the brief of the story and then the subsequent development that happened. And as usual, since this is a Supreme Court judgment, the application was prior to this was with High Court, and High Court dismissed it for XYZ reason. As a consequence of that, it went to Supreme Court, and from the Supreme Court, the appellant here uh, got the relief, and this appellant was able to quash the proceedings and set aside the judgment passed by Allahabad High Court. Now, this is the story. This appellant here is an additional director with respect to this judgment. He is a co-accused, if you would like to think it in that way. The main accusation or the allegation is against someone else. He is a co-accused. There is one more individual. So, in uh, and one other thing, they all are sort of business partners, and for a quite some time they were engaged in some sort of garments or import business. Some disputes were there. Now, as a consequence of that dispute and some other allegation and then counter allegation, this complainant, who is a woman, uh, filed a complaint before the concerned police station, and the charge sheet was filed under 354 and 506. Then the appellant went to the High Court to quash the proceedings, did not get the relief from there. High Court sustained, uh, you know, the proceedings, and then the appellant subsequently came before Supreme Court, and from the Supreme Court he was able to quash and set aside the judgment. Now, the main uh, in this entire judgment, the key question that Supreme Court reflected upon is this: whether under 482 CrPC, criminal proceedings can be quashed or not. Now, in case if you do not know what 482 CrPC uh, is, just like writ jurisdiction, 482 CrPC is an appellate jurisdiction that ordinarily used to quash or set aside judgments by the trial court. Now, charges. Okay. Now the now here is the main thing that Supreme Court came across. That is the statement which was recorded under 161 and 164. These are the two statements. And one common practice before police station or even before trial court that I have seen कि लोग क्या करते हैं ना जाके अपना दुख बताने लग जाते हैं rather than getting into the facts and the circumstances. They will talk about everything. They'll talk about their, their family, maybe the neighbor's family, the entire politics. But they focus, since mostly that is because they're overwhelmed with their emotion, they leave out the critical components, which are the legal aspects. Because you can file 500 pages thesis or dissertation before council, but they will only look into some of the main ingredients that can help to sustain your case. They are not interested in your sad story. So अगर आप प्रैक्टिस कर रहे हैं या फिर आप litigant है, please do not go before court with your sad story. uh, this is not a stage where you can perform your drama. Usually those sort of things even dissuade the court. Even if you sometimes have some merits, you might lose your case just because you didn't stick to the main issue. Because they are also human being. All the things that you bring forward, they would also tend to look into everything, and in doing so they will lose. There is going to be some oversights, and if that happens, you are bound to lose it. So it is always advised, stick to the facts, stick to the circumstances, and stick to the details, not your sad story. Now, what while deciding, so these are the two things that if I go to page 9, uh, the apex court had only had to decide whether the prima facie case was made before the court or not. That was the criteria that was set by the apex court to decide whether they can quash the proceedings under 482 or not. Now, first they go into the definition of the charges for 354 and 503 and 506. Now, uh, here there are numerous judgments which are there that you can refer to. I will just go to one particular judgment, that is Indian Oil Corporation versus NEPC India Limited. And this particular judgment is relevant because most relevant, that is because this lays out the groundwork in deciding whether criminal proceedings can be quashed under 482 or not, and if it can be done, what all factors to be considered. And the number one factor is the prima facie. आप सबको पता है prima facie means कि basic जो उनका allegation है, whether that allegation is substantial or not. It's a very simple question. And the way you make a prima facie case is by maintaining two things. It's very simple. Number one, facts and the circumstances, or in other way, the cause and effect. So whenever there is a complaint, there must be some cause that led to that effect. You need to be very clear about those things. Don't go before judge, or whether you are making a statement before police, that will be recorded under 161, and if you are making a statement before magistrate, it will be recorded under 164. Don't start talking about your sad story, how you were victim, how you were assaulted, कहाँ कहाँ आपको टच किया, कहाँ कहाँ आपको पीटा, सर में पीटा, ये पीटा, वो किया, मेरा कपड़ा फाड़ दिया. So this is what the tradition is in the trial court. But believe me, when these sort of things go to high court or supreme court, they are not interested in your story. They want to look into the facts. So stick to the cause and what led to that altercation. What was the motivation? Karan kya tha? Why it happened? There must have been some reason. So you focus on these details: why, when, how. If you stick to these characters, these WH characters, the prima facie case will be made and probably you will get the justice. अगर आप prima facie case नहीं बना पाते हो, आप what happened, this happened, that happened, मेरे साथ ये हुआ, मेरे साथ वो हुआ, you will lose out on the facts. So, and this is exactly this judgment uh, wherein Supreme Court set aside the High Court judgment and quashed the proceeding is because no prima facie case was made. ये औरत ने जो 161 के जो स्टेटमेंट दिए या फिर 164 में, मोस्टली आई रेड इट, आई कैन अगेन रीड इट बट इट विल नॉट हेल्प यू एनी वे. यू कैन रीड इट, यू कैन डाउनलोड द जजमेंट फ्रॉम द सुप्रीम कोर्ट वेबसाइट. She was mostly talking about her stories, like what she did this, or sorry, he did this, he did that, he touched in this place or that place, he ran, he assaulted, he did this. So it's basically, what, know why, when, how, all those things were left out, which are all very essential elements to make a prima facie case. And as a consequence of it, this matter was uh, closed, or this matter was the proceeding was uh, quashed. And one other thing you should also know, that the statement that you make under 161 is not a substantial evidence. बहुत लोगों को लगता है कि बहुत सारे धाराएं लगवा दो, मेरा काम बन जाएगा. No, that is a, you'll be very very mistaken. The moment you add multiple sections in a, because ये कॉमन मैंने देखा है, लोगों का एक आदत रहता है, ये धारा लगवा दो, ये धारा लगवा दो. You remember, when it goes to trial, you have to also sustain those sections, and that is not easy one. So better you stick to maybe one or two core uh, sections which are relevant to the most, and leave out the rest. And one other mistake that people commonly make, and as a consequence of this particular uh, judgment, uh, or this application was successful because in this case the appellant is co-accused. Now again, with respect to this, I'll tell you something. लोगों का ये एक आदत होता है कि खास करके डिवोर्स केस में भी बहुत होता है, that the wife will try to rat out the entire family. Sometimes even people who are living in some remote location, so maybe they are living in Kolkata but the in-laws are living in Delhi, Mumbai. I do not know how they get this sort of ideas or imagination. They will also implicate in their cases, bring out their names. And in this case, it's also quite similar to that only. Even though this person had very little in this entire allegation, the main allegation was somebody else, and somehow this lady felt that including maybe him would also benefit her case, which is completely wrong. And this undermines again in case, if let's say in high court or in the supreme court, if one of the co-accused, let's say in a case you have principal accused and then you have multiple co-accused, if they start getting bails, or if they you know are successful in getting the proceeding quashed against their name, your case also becomes weaker and weaker. So stick to the main character, who is the main perpetrator, or the person who is really, guilty probably. In that way, you will be able to sustain your case. Otherwise, it will get either quashed or get set aside in uh, appellate courts. So that is what exactly happened here. You can see this appeal was allowed, and I think here, yes, the impugned judgment by the High Court was set aside, and the criminal proceedings was quashed against this co-accused. So couple of things just to summary. जब भी आप अपना केस दायर करते हैं, stick to the facts and the circumstances. Think about why, when, how long, how far, all these wh things. Don't go for your sad story. It will not impress the judges, and it will not help your case. Second, don't implicate unnecessary individuals, because if they are, acquitted or maybe released, in that case your case become, weaker and weaker. So uh, make sure that you have a proper case, and you only include those individuals which are necessary for the justice. Don't go for the family or additional people just for sake of maybe vengeance or out of some, grudge. So that's pretty much everything for today's judgment. Let me know if you have any question. Thank you.